Looks like the appellees are ready too. I know they're ready. They've been sitting there a little while. Okay. We are here in the matter of Livingood versus City of Des Moines. Ms. Diallo, it's my understanding you will argue again? Okay, thank you.
May it please the court, counsel. In an increasingly automated and digitized world where the issuance of citations for alleged traffic violations can be automated, the resulting determination and enforcement of those liabilities cannot be automated. Determining liability, like guilt or innocence, cannot be automated. Accusations of liability in the form of notices of violation have been automated in each of these cities today, and including Des Moines, and can be sent to vehicle owners and challenged by those owners in an administrative hearing. Weisberg, Boehm, and Leaf all affirm those propositions. But those are different questions than when trying to enforce liability penalties by seizing funds involuntarily. Actual liability cannot be determined involuntarily without a municipal infraction lawsuit convened by an independent judge. And no seizure of funds owned by a vehicle owner can be made without having a judgment of liability entered first. It is the involuntary nature of this enforcement of an alleged violation that has not been subject to the entry of a judgment that is at issue in this appeal. Plaintiffs challenge the involuntary enforcement of a penalty that is not preceded by the judgment of liability. This court has never allowed the automation of the involuntary enforcement or the automation of the involuntary determination of liability. It should not do so now. A human with agency is needed in the process to review, to consider, to determine, to judge. And the plain meaning of involuntary enforcement in the context of alleged municipal infractions forms the core of the differences among the parties. Indeed, involuntary enforcement is the key to two crucial concepts. First, with respect to the preemption of the City of Des Moines' use of the offset program, and second, as applied to the statute of limitations protecting vehicle owners, which I focus on in turn. The clearest line drawn by this court is how to involuntarily to enforce an alleged violation of an ordinance or a municipal infraction. The Iowa General Assembly in Iowa Code Section 364.22 set forth the manner in which to enforce a violation of a municipal infraction and obtain a judgment of liability. In order to collect fees or penalties for an alleged violation where not voluntarily admitted and voluntarily paid, cities must follow Iowa Code Section 364.22, file a lawsuit, demonstrate service of process on a vehicle owner, and obtain a resulting judgment of liability. It is true that prior to an involuntary enforcement, the city may offer and a vehicle owner may choose to participate in an administrative hearing process. However, if the
something with respect to these three plaintiffs, Livingood, if I understand it, has not paid a citation. Is that right?
funds were held in the offset program many, many years ago, and then after receiving a letter from Counsel, they were released. And at that time, he was told that they would not be pursued at that time.
Pronounce Maury, is that how you pronounce that name? Maury got notice of the offset, but then called and consented to the payment. Is that correct?
That he agreed for the return of $812 to pay $65. Consent, I wouldn't perhaps use the word just because it sounds more in coercion to me once your funds have already been taken and a young family is relying on that tax return in February. And then Mr. Robbins had 100
actual consent under the circumstances, but he did call in and say, I authorize you to go ahead and do this and release the refund.
The funds were already seized and held in the offset program. He did call to figure out what had happened and in order to obtain the rest, agreed to that.
Whereas $130 seized.
Return, yes, Your Honor. At any municipal infraction trial, the city bears the burden of proof to demonstrate a violation by clear, convincing, and satisfactory evidence. If the city proves its case, a judgment against the defendant is issued. And if not, the court shall dismiss it pursuant to Iowa Code Section 364.22(6)(f). There are a myriad of provisions that are required by the Iowa General Assembly to be followed in order to obtain a judgment of liability against an individual for committing a municipal infraction set forth in Iowa Code Section 364.22. Instead, however, the City of Des Moines provides for an entirely different process in its ordinance. And it's Section 326 through 329. 329 describes the appeal of offset and indicates that, quote, if a hearing or issuance of a civil citation is not timely requested pursuant to Section 114.243.2 or pursuant to an administrative hearing available at the time the notice was issued, the notice of violation is deemed a debt subject to placement in the Des Moines Debt Offset Program for purposes of appeals under this section. Des Moines has entered into an MOU with DAS under which they purport to be able to place a civil penalty resulting from an alleged ATE violation, but not actual proof or judgment for the same in the state income offset program. This MOU and the ordinance that attempts to allow the same is irreconcilable with the minimum requirements of Iowa Code Section 364.22.
At the end of your last argument, you started to talk about liquidated, how it became a liquidated debt and why that the offset provisions still required it to be reduced to judgment. Could you address that, please?
So under Iowa Administrative Rule 40.33, and plaintiffs briefed the issues of defining a qualifying debt, and there's some difference in how you define that, and it was recently amended effective January of 2021. But really, when you look at how even liquidated is defined under the rules, it's clear that these ATE citations for liability cannot meet the definition. And this is under subsection A. The debt shall have been established, parentheses, liquidated by one of the following means. 1, mutual agreement between the debtor and the public agency. 2, alternative procedures authorized by applicable state or federal law with respect to a, quote, qualifying debt as defined in Iowa Code Section 8A.5041. Or 3, court proceeding or administrative process which included notice to the debtor and an opportunity for the debtor to contest the amount of the debt through a contested case procedure under Iowa Code Chapter 17A or substantially equivalent process. Then this section goes on, and it is clear at the outset that it says all of the following conditions have to be satisfied. And under subsection B, the debt shall have been reduced to a final judgment or final agency determination that is no longer subject to appeal, certiorari, or judicial review, or shall have been affirmed through appeal, certiorari, or judicial review. And C, finally, the debt shall be an amount certain that is past due and not subject to any legal prohibition to collection. And the city actually promises in its MOUs with DAS that it will comply with these requirements. But placing...
On one of the provisions, I think C, from that admin code, the one I'm reading says, such liquidated sum may be accrued through contract, subrogation, tort, operation of law, or any legal theory regardless of whether there is an outstanding judgment for that sum. How do I get around that?
I think you're looking under a different section.
10-40.1.
And so in that language, 1140.1, it still describes liquidated sum. And so that actually keys right into my point, because we had originally considered that that might be ultra vires and not consistent with the governing statute. But in fact, the rules make it clear that liquidated is defined in a way consistent with requiring a municipal infraction. And so even in both the language that Your Honor just cited from subsection C, it still has to be a liquidated sum due, owing, and payable. It used to be to the district court clerk.
Statute. Didn't we say in Boehm and Weisberg that the money isn't due until there's been a municipal infraction proceeding initiated, and that we blessed this, I think we called it an additional, supplemental, alternative, voluntary procedure where people could go and have their administrative hearing. But if they decided not to pay, nothing was due until the city marshaled the resources to go ahead and pursue a court proceeding, regardless of statute, right?
Honor, that is plaintiff's reading of Boehm as well, and Weisberg. And so we just wanted to clarify that there really is the district court below in this matter seemed to be trying to reconcile the offset procedure statute and 36422 as if there were some conflict, and there really isn't. It's only in the city of Des Moines' use of this offset procedure that a conflict arises, and we...
Being said, so my question for you then is still, how do you get beyond declaratory relief or injunctive relief to money damages? And there are a lot of cases involving claims against government departments, municipalities, where even if statutes and ordinances weren't followed, there's still not necessarily an entitlement to receive repayment. So how do we get there, in your view, from your claim that the ordinance wasn't followed or the statute wasn't followed to a claim for monetary relief? Because I don't see it.
So that again, Your Honor, the clearest way is under unjust enrichment. The city has admitted the first two aspects of unjust enrichment under this case. It has a receipt of a benefit, and it was to the detriment of plaintiffs. So the only question is the third element of unjust enrichment. And plaintiffs think it's clear, particularly given Boehm and Weisberg before this and the continuing actions of Des Moines, that it was unjust for them to undertake this and to continue to do it to the detriment of these plaintiffs, and it therefore should be remitted.
Body of law that says in kind of non-proprietary context, or where the government is just exercising its government functions, that unjust enrichment won't lie against government entities. We have a body of law that says even where government entities don't comply with the law, there's not a due process violation. You could have curative acts. I guess I'm very hesitant or reluctant to conclude that there's monetary relief available here as opposed to declaratory injunctive relief.
Well, a couple things on that. First, I think it's important that plaintiffs sought an injunctive relief very early on in this case in 2017, and so all of this could have been prevented. The city could have been stopped in 2017 for the past 6 years of collections, and I think that's important because unjust enrichment at the end of the day is an equitable theory of relief. And in terms of the city acting as a government agency, I think when it's acting outside, when it's violating the law that clearly applies to it, then unjust enrichment is a perfect equitable relief to consider in that case, particularly if there's nothing else that readily fits. But how are they able to obtain their funds back other than unjust enrichment, which is the clearest claim of relief, plaintiffs would say.
So the injunctive relief would be pay it back. And was this styled as a putative class action originally? And did the court address certification or not? Not yet. And the fact that you filed it as a putative class action will stop the clock for all class members until that's determined, right? So this is potentially a pretty sizable refund claim on behalf of everybody who's had fun, if you win on the merits.
Standing from 2015 to 2018 that the city of Des Moines had seized $1.3 million from 11,500 individuals, and that doesn't count the last several years.
Would it be an opt-in or opt-out class action, or are we getting ahead of ourselves?
Out just because I think that it would be fair for the default to be that you're included, particularly given how the default came about in this case for people to be included in the offset program. Finally, I just want to say a couple quick words about the statute of limitations. And it's particularly striking when you look at Mr. Robbins's claim. So he had a notice of violation from a 2012 citation. Then he had another notice of violation in 2015. Then in 2016, so 4 years after his original notice of violation, and a year after the city entered into the MOU with DAS for offset procedure as applied to ATE, he had $130 of his $205 refund seized. Now, this is 4 years after, and this is very clear statutory interpretation. The Iowa Code Section 614.1 doesn't say in a court action you have to bring within a year. It says in order to enforce a forfeiture or a violation of an ordinance, which is exactly what we have at issue here. And so that we don't have it, in this case, the juxtaposition of using the statute of limitations as a sword and a shield is a real concern for vehicle owners. Thank you, Your Honors.
Ms. Mackel?
May it please the court. My name is Shelley Mackel. I'm an attorney for the city of Des Moines, and I appreciate the opportunity to be here today. I want to start with a discussion around our rules in terms of statutory construction, and that we are directed to have an eye toward plain meaning and accepted usage. And we're also required, when we're comparing statutes to statutes, statutes to ordinance, we're required to find harmony when harmony can be found, and only when harmony is impossible are we to reject this sort of preemption issue. So the plain language of 8A 504 sets forth two kinds of debts that can be included into the offset program. The first is a qualified debt. It includes a list of items that are qualified debts, and those are sort of DHS debts.
Maybe others remember, I shouldn't cut you off because there might be others interested. I actually agree with the city on 8A. My problem is what we said in BAME. And I really want to hear what you have to say about that, because I thought we made it really clear that you know, if the owner of the vehicle doesn't cooperate with this citation process, then you're backstop. You have to go after them with a municipal infraction and go through all that.
Before this court, so I'm intimately familiar with the facts and the law in that case. So
Last member of the Lion King or something is what I remember. Is that right, Mr. LaRue? Yeah.
a musician, I think? He was. Yeah, and unfortunately, he also didn't know about, for example, the Windsor Heights speed trap, and that everybody locally would know about. But the issues in terms of the Weisberg and the Bem decision is that the court simply did not have access to the question about, well, what do you say about 8A? Because it seems to set forth this issue that the legislature has envisioned a different path. And so my read of Weisberg and Bem is not quite the same as Mr. Richards, but I believe that the case could only be read in the context before this question was presented. And so it does have to have some limitation. So when you look at 8A and you see that the court or the legislature has used any debt that's, that's attributable to or owed to a public entity, no one in the Weisberg court or the Bem court had to ask the question, well, what does that mean?
But, so what you just said is it's a debt owed. And I think the statutory language, so I understand it says any liability, and you say that's very broad, and it could cover this. But the statute goes on to say, unless I'm mistaken, it has to be due, owing, and payable. And I think what we said in Bem and Weisberg is it's not owing.
And I guess then I have to put that in the context of arguing that due and owing does not mean a liability through a court judgment. And in particular, as the plaintiffs were just arguing, that this portion of the rules that say that it doesn't have to be a judgment, but the fact that they use the term liquidated sum means that it's a judgment. So how can it be that it has to be a judgment, but it doesn't have to be a judgment? That renders that portion completely unreasonable. And so DAS has clearly set forth that we don't need a judgment as a public entity to access the debt offset program. And there are reasons for that.
That's owing, whatever you want to call it. And I'm going to say Beam. Whoever had the plaintiff in the case can tell me whatever. Beam and Weisberg said it's not owing. And it didn't say it's not owing for this purpose or this statute or that statute. It said period, full stop. This is a voluntary procedure and it only complies with due process because it's a voluntary alternative procedure. And once it becomes involuntary, the citation can't be enforced because it's not owing.
And then I go back to the rules where a legally enforceable debt is defined as a court proceeding or an administrative process, which included notice to the debtor and an opportunity for the debtor to contest the amount of the debt. And so that is the definition through DAS as to what kinds of debts constitute something that is due and owing. We've gone through that administrative process, they've had their opportunity, and at that point, that debt becomes due and owing. I believe that's the most reasonable read of the DAS rules, and that's one of the reasons that I find it interesting at this stage of this case that the position is being taken that the rules of the statute are all fine, because initially there was a claim that the rules were ultra vires. And the problem that the plaintiffs then continuously ran into was, well, then why isn't the state a party to this case? If you have a problem with the language of the statute, you have a problem with the language of the rules, then the state should be included in this case. And that was repeated multiple times by district court judges. I want to move back to Justice Mansfield's question about getting to the root of how do we deal with the language in Weisberg. So again, without having the benefit of having any argument, any briefing, any analysis about AA, the court did not have that broad language in front of it. It didn't have the rules in front of it. And as someone who argued that case, it was clear to me that the court was telling the city of Des Moines to get back in its lane because it was acting as if it was making rulings, making judgments. And I say that because the language in our notices was very strong, and the language in our administrative proceedings actually called the outcome a judgment. And so I felt the opposition from the justices during that argument and had to concede that the language was not appropriate. And so my read of Bem and Weisberg is cities, get back in your lane. Stop acting like you have the power to make a judgment. And I think that's how we end up harmonizing the statutes in this case, the rules in this case, and also the city of Des Moines' actions, and the Weisberg language and the Bem language, which is, sure, the city or the court was telling the cities, stop acting like you have judgments. Stop threatening people like you have judgments. You don't have the power of the court. You cannot get tax sale benefits. You can't get liens. You can't get garnishments. You can't get an injunction. You can't get contempt on these things. So stop acting like it. And so that is my read of Weisberg and Bem, especially in the context of the court not having had the benefit of having the 8A arguments.
So let's say hypothetically we didn't have that language in Beam and Weisberg.
Sure.
I mean, there would still be the argument, which is that in order to enforce a violation of an ordinance, which this is, your ultimate remedy is only to pursue a municipal infraction procedure. How else would you ultimately be able to enforce? What other tool has the legislature allowed the cities to use?
Well, I would embrace the dissent that you and Justice Waterman filed in Weisberg and Bem, where you indicated that your read was not that this was a mandatory, that it was that the municipal infraction statute was not exclusively designated as the only way for a city to collect a debt. And you said cities ought to be able to get, put informal processes together so that they can collect these sort of minor debts without going through this formal court process. And so I would say that 8A is what has given us that.
That maybe that it doesn't really make sense to file a municipal infraction proceeding for $65, and that the end result of these cases is probably the cost of these tickets is going to go up for everybody. But in the meantime, I'm not sure that the majority is wrong in Beam and Weisberg that's the only way you can enforce if you actually have to enforce it as opposed to get the owner of the vehicle to do something voluntarily, that ultimately, if it's enforcement, it has to go through 36422, right?
Problem with the statutes being contradictory. And that's where we have to try to find the harmony. So if it's at all possible to find the harmony between those two statutes, then that puts us in the position of saying, well, the legislature had to mean that these two things could exist simultaneously. So that has to mean that you can get a really powerful judgment if you want, or you can get a much less powerful collection tool if you take the path of going through the tax offset program.
We were outvoted in a dissent's not the law.
But
True that 8A wasn't an issue in that case.
absolutely not an issue in that case, but I will say that every one of the notices that was in the record contained the tax offset language. And it was a voluminous record, but at no time did we stumble on the court saying, hey, put the brakes on, what is this tax offset thing that you've got going on in these notices? And so while there weren't any citations, no argument, at least the admission that the city was using the tax offset program.
Distinguished Beam and Weisberg, those didn't address the potential conflict or interplay with 8A, and you get a fresh crack at that in this case.
That without the benefit of the court being able to analyze 8A, it couldn't say, well, if you're going to go for an infraction, you have to follow the infraction statute, but it looks to me like the state has provided something else.
Is the city of Des Moines, does it have any other procedures to collect that don't involve getting a judgment through 36422? I'm thinking, for example, I have a septic tank, and every year I got to pay a $40 fee to Scott County. If I don't pay that, can they just go right in and offset my income tax refund, or?
The regs would require us to have a hearing with you, to give you notice and provide that opportunity for hearing. And so, as I think was asked previously to Mr. Richards, there are other kinds of debts that the city uses the offset method for, but there are also, things, if you don't have a permit, we can actually, enjoin you from going any further and make you pay for that permit, doing things like that. And so, but there's also the issue of, for example, ambulance bills. They go to offset collection, and they get a notice that you use the ambulance, there's this much money at that cost, and either pay it or we're going to send it to offset. So that is another example that wouldn't necessarily be a violation of the ordinance, except that a bill is not being paid. And that's similar to.
He's making a legal determination that this person has violated an ordinance, and the penalty comes from violating the ordinance. And the code sets forth a certain procedure for how you prove a violation. So it's kind of like a guilty plea, right? Like if somebody wants to come in and pay the ticket and not go through the process, that's fine. You don't have to get the full panoply of due process and trial, et cetera. But if the city wants to violate or enforce it, then it needs to go through 36422, right? I mean, I think that's what Beam and Weisberg say. And following up, could you explain in more detail? I don't understand the conflict you're claiming between 8A and Beam and Weisberg and 36422. I'm not sure I'm following you.
Conflict, I think the court simply didn't have an option to review it. And so when the court said there is no other possible way to collect money involuntarily, and yet there's a statute out there that clearly says we can, clear to me, I believe, then it's not so much conflict, it's just two ships that missed one another.
What we said is with respect to ordinances and the ATE ordinance, that the amount of the citation could not be enforced. It wasn't due and owing until the 36422 procedures were complied with. That doesn't mean that we discounted the fact that there could never be something that could be enforceable that wasn't done in court. I think the statute talks about administrative decisions of other agencies, but all we said was for that purpose, for a citation, city ordinance, it's not enforceable unless you go through 36422. So I'm not sure how the statute defines or can redefine what we concluded was due and owing under a municipal infraction.
And again, I go back to the fact that I think then we have conflicting statutes, because if that language isn't clear enough, that any debt, whether or not it's reduced to a judgment, it doesn't carve out except ATEs, anything that could be a municipal infraction, it doesn't say that. And so the fact that and quite frankly, I think the new statute, and I apologize, I see my time is up, the new statute that has been, I don't think it's any surprise to this court that the legislature watches what this court does, and it certainly watches what the city of Des Moines does and responds. And so the fact that this case is pending and there's a new statute that clarifies that it means any public debt, I think is a clarification that that is what the legislature meant. With that, yes.
With the chief's permission, I got a follow-up question. For the tax offset, does it have to be liquidated? And what does liquidated mean?
Definition of liquidated means that the amount of the claim or debt is definite, determined, and fixed by agreement of the parties or by operation of the law. And we've argued that it's by operation of the law. We have a schedule of fees. And so the ATE is fixed at $65 by operation.
Say, the amount is set by the schedule of fees, right?
Yes.
But is the fact that this person, or that it's the right license plate, or, any of those other challenges, is that determined? I mean, that's the part of the due and owing part, I think. So how is that set by law?
Your Honor, that before any of this goes to tax offset, there is an opportunity, and that was at the core of the Weisberg case, there is an opportunity for the vehicle owners to contest the actual violation. And so there are two notices that go out about that. There is the option of admin hearing and/or a municipal infraction. And so it is only after the deadline for that has passed, or that they've lost at the administrative level and have not asked for a municipal infraction. And at that stage is where the tax offset comes into play. And so there are these opportunities to be heard and contest.
But you were saying liquidated is by operation of law, which goes back to the schedules.
To the schedules, that it's $65, so at the end of the administrative process. Yes, and at the end of the administrative process.
Tell me where by operation of law that says what's owing, that this person is what owes this liquidated amount.
Going through the process of the administrative hearing.
It's waiving the process, and that's the operation of law.
Do I sit down? Okay.
What version of the Des Moines City Ordinance is operative in this case? What year?
In effect at the time. So it said,
243. I just want to make sure I'm looking at the right ordinance, the right language. D3, I think, and correct me if this has been changed or if it's the wrong ordinance, says if the recipient of the automated traffic citation does not pay the civil penalty by the stated due date or request a trial, then the city will issue a municipal infraction. Said municipal infraction citation will result in a mandatory court appearance by the recipient, as well as the imposition of state-mandated court costs if a finding of guilty is made by the court. Is that the ordinance that's controlling for the purposes of this litigation?
you wouldn't ask me that question.
Comply with its own ordinance in initiating traffic citations?
Squarely at issue in the Weisberg case, and it became that exclusivity argument that that was the only option. And the city had another option that was not codified in the administrative process, and that was approved. And so it is the approval of that administrative process that came through Weisberg that allowed the city to know that it was able to use the tax offset program.
That being said, the city is violating its own ordinance
Indeed, but
mechanism.
argued in this case, nor in Weisberg.
Troubling as the attorney for the city that it's decided that it's going to, in my view, ignore Beam and Weisberg, ignore its own ordinance, and then decide to bypass court proceedings to enforce judgments against people because it finds it too cumbersome to comply with its own law.
I do find that troublesome, and that is why the statute or the ordinance was changed after Bem and Weisberg. The city also ceased all collection activities through the debt collection process. It's important to know that this case was filed before Bem and Weisberg were filed. And so those cases went through the process, but the moment we got the decisions in Weisberg and Bem, we halted that offset program to allow this court to resolve this case so that we were not running afoul of that. And we also changed the ordinance language to comply with the court's order.
With respect to these folks, contra to its own ordinance.
Certainly not, yes, prior to Bem and Weisberg coming out, yes. Anything else? Thank you.
I'll try to cover quickly. Just want to start from the end again. So a couple things. The city violating its own ordinance, plaintiffs did argue that. We argued it was preemption, and the city responded that that was more of an ultra vires argument, whatever we call it, form over substance. We do think that's an issue and it's a problem. And I would just note that the city just cited Weisberg to say that it then decided it could use the offset program, but had previously argued that Beam did not stand for the proposition that it could not. And so in trying to make these items, these statutes harmonious, which plaintiffs think are harmonious, but also think that Beam was clear in drawing that line, because it had to draw a line in order to make the statute of Cedar Rapids, the ordinance of Cedar Rapids, harmonious with 36422. So Beam already drew the line, and it wasn't just dicta. It had to do that. It had to say you can and cannot do certain things in order to make it harmonious and not preempted. And so that's why what Des Moines is doing now, and I'm not sure, I think I just heard that they weren't doing it for some amount of time. That would be news to me, but I would be interested to know about that. So I think it's also important, this has come up several times, I think the city of Des Moines, along with Windsor Heights, is judicially estopped from arguing that DAS should be a party here. We really think DAS was an innocent party here. They were told that the law would be complied with, that these were legally enforceable debts, that they were liquidated, and they were not. But moreover, the city could have joined DAS if it wished to, but it in fact argued in the DAS action that was filed under the administrative rules that it could not be decided at the time. So, and also under 1.2343, looks like the court also could have added if it found that it was a necessary party. I also just want to describe, there was something about the notices in the record always informing individuals about the offset program. And I think this is important because it's sort of shocking when you look at it side by side. So we have in the appendix the notice that is sent right before the offset program of Des Moines is instituted. And this is Appendix 208 and 209, and I'm sorry, it's actually quite hard to see the numbers because sometimes they're over the other numbers. Notice that too late. But the old notice from the city used to say that if you wish to request an informal hearing pursuant to Municipal Code Section 327, which is Des Moines' new offset ordinance that was passed in 2017, so before Boehm and Weisberg, regarding a placement of this debt in the state of Iowa, you must submit a written request to the finance director, and then the email is provided and the phone number. And then in the new ordinance, none of this information is provided anymore. And the last day was 2019 to pay, and the first one was 2018 to pay. So it's clear that this is the new one. And so it really is actually less notice that the city of Des Moines seems to be providing, despite its protestations to the contrary. I think we talked about 40.33 and liquidated debts and what that means, and I think that's important in terms of the definition. And I was interested to hear for the first time the city describe as having alternate mechanisms of enforcement, because what it argued in the brief was that it had alternate remedies. And we think that's really a problem because this is the same remedy. And the city seems to think that the court was concerned with, in Boehm, with the fact that it had pieces of paper saying judgment, total, and liability. And while that was a concern to the plaintiffs there, we think it 100 times more concerning to actually just take those funds, from a tax return without any such judgment by a court, without any of the processes that were followed. And so while we understand that there were some notice issues in Boehm as well, really the crux of this is to have no judgment, but treat it with all the power of a judgment, even more powerful, because it can be enforced at any time. There's no statute of limitations, according to the city, for these offset procedures. It can decide 5 years, 10 years, 20 years later that it wants to put something in an offset program. It does not admit that 614.11 applies to it. So in closing, Your Honors, I would just say that this court cannot condone trial by mail, seizure by deception, and liability by edict. Thank you.
Versus City of Des Moines is hereby submitted. The court will take a brief recess, and then we will reconvene for the final case of the day, which is in the matter of medical assistance pool special needs of Hewitt.